Hello, everyone. Today we're going to tackle one of the most challenging issues at the intersection of law, technology, and society: misinformation, disinformation, and the First Amendment. We're going to explore the delicate balance between protecting free speech and combating the harms of false information in our digital age. Our central question will be, in a free society, who gets to decide what is true? First, let's establish our key terms. Misinformation is false information shared without the intent to deceive. Think of it as an honest mistake or rumor that gets passed along. Whereas disinformation is false information that is deliberately created and spread to mislead or cause harm. It's an intentional lie. Now, there's a crucial constitutional point here, and that is the First Amendment generally protects both. The government cannot punish someone simply for saying something that isn't true, whether it's an accident or a deliberate lie. This principle is the foundation of our discussion today. So when can our government restrict false speech? So, yes, there are limits to when the government can restrict our speech, but it's very narrow and it's very specific. The Supreme Court has carved out a few categories of speech that's not protected because the harm they cause is direct, it's tangible, and it outweighs the value of free speech itself. These include defamation, which is false statements that harms someone's reputation. And these are laws that allow for compensation in terms of monetary form because you can actually quantify a dollar amount once you go through the court process. Fraud. Those are false statements made for material gain, and this is mainly used to protect us, the consumer, to protect economic fairness and safety for us, the consumer. Incitement, which is speech that provokes imminent lawless action. It's illegal because it creates imminent danger regardless of the truth. Then the last is perjury, which is lying under oath. It's criminalized because it undermines the integrity of the judicial process and the judicial system. Now, notice that all of these are tied to a specific identifiable harm, not just the general harm of a lie being present in public discourse. And we're going to take a look at 3 court cases that is of recent that are very important and addresses this issue. Now, the modern foundation for the principle of free speech comes in the 2012 case United States versus Alvarez. Now, Javier Alvarez, a local politician, falsely claimed at a public meeting that he had received the Congressional Medal of Honor. Now, he was charged under the Stolen Valor Act of 2005. And it's a federal law that made it a crime to lie about receiving military decorations. However, the Supreme Court in the 6-3 decision struck down that law, the Stolen Valor Act of 2005. They ruled there is no general First Amendment exception for false statements. And Justice Kennedy, writing for the court, famously stated that the remedy for false speech is not censorship, but speech that is true. The court feared that allowing the government to punish lies would create a chilling effect on all speech that could give the government a dangerous power to act as a ministry of truth. That's always been the concern. Second one, this brings us to the modern internet in 2024. This is when the Supreme Court addressed two major cases involving social media. In the net choice case, Florida and Texas had passed laws trying to stop social media platforms from censoring political viewpoints. The states argued that the platforms like Facebook and X are common carriers, kind of projecting them as like a phone company, and should have to host all speech neutrally. Well, the platforms argued that content moderation is a form of editorial judgment protected by the First Amendment. Just as a newspaper chooses what to print, platform chooses what to host. And the court sided with the platforms and it strongly signaled that platforms have their own First Amendment rights. The act of choosing what content to host, promote, or remove is a form of editorial judgment. So much like a newspaper editor choosing which articles to print. Therefore, the government cannot force a private platform to host speech that it disagrees with. And the last one is Murphy versus Missouri in 2024. Now, this is about government pressure and the act of jawboning. And now the plaintiffs argued that the Biden administration had unconstitutionally coerced social media platforms into removing misinformation about COVID-19 and the 2020 election. This practice is what is called jawboning, and it's informal government pressure. Yet the court did not rule on the merits of actually whether the government's actions were illegal. Instead, in the 6-3 decision, it dismissed the case on procedural grounds, ruling that the plaintiffs, they lacked standing, and this means they couldn't prove a direct causal link between the government's communications with the platforms and the removal of the specific post. The court found it was just as likely as the platforms were simply enforcing their own rules. And this leaves the central question of jawboning itself, whether, when does the government persuasion becomes unconstitutional coercion? And that remains a question that has not been answered today. Now, these three cases that we just examined, they highlight the most misunderstood concept of this debate, actually. It's the state action doctrine. The First Amendment begins with the words, Congress shall make no law, and what that is a restriction on the government, not on private individuals or companies. This means that government cannot censor you. But a private company like Facebook, X, or YouTube is a private actor. They have their own First Amendment rights to moderate their platform as they see fit. Now, this includes removing content or banning users who violate their terms of service. Your free speech rights don't require a private company to give you a microphone. And so there's an ongoing tension that is going to be dealt with for years to come until it's resolved. And there's the first tension, safety versus liberty, regulations versus rights, and truth versus trust. And we're left left with that fundamental question. And on one hand, we have the value of safety. We know that misinformation can cause real-world harm to public health and the democratic process. And on the other hand, we have the value of liberty. We fear that giving the government the power to police truth could lead to censorship and the suppression of dissent from the government itself. So giving the government that much power can cause itself to become too much powerful and not be able to exercise checks and balances that the Constitution grants. Now, that is the core dilemma. The American legal tradition, for better or worse, has consistently chose to protect liberty, trusting that the marketplace of ideas and more speech, not less, is the best way to find truth. Now, given that, what is the role of social media platforms? Now, as private companies, they are the primary moderators of online speech. They're caught between public pressure to remove what is deemed harmful content and the accusations of bias and censorship when they do. Now, the Net Choices case that we went over, it affirmed their right to make these editorial choices. But also the Murphy case we looked at shows that they must do so without being coerced by the government. This places immense pressure and responsibility in the hands of these companies. Now, if the government can't be the arbiter of truth and platforms have their own agendas, the primary responsibility falls on us, the citizens and consumers of information. This is where media literacy becomes the most powerful tool. Now, before you share information or buy into information or deem it true yourself, you have to ask yourself these questions as kind of a guide. Who is the source? What is the evidence? What is the tone of the information you're getting? Is it hostile? Is it positive? Does it confirm my own bias? By thinking critically and verifying a lot of the information, we become our own true speech advocates for ourselves. And this is exactly what Justice Kennedy was talking about. We actually become the remedy. We solve this problem ourselves, and that's our responsibility as citizens. And so this concludes our look at misinformation, disinformation, free speech, and the government's role. And ultimately, like I stated, the conclusion is that it may be our role. And so be prepared for a reaction to this. And I hope you got some good information.